long does it go? So I said, if, my letter did say, if I can assist you in identifying what you're looking for, please give me a call. Yes, sir.
Can you go back one slide?
Certainly.
Just that there's a disconnect for me from what you said and what appears here. That
Okay,
says what is a public record, communications received from legal counsel, and then you're saying except if it's regarding pending litigation?
Correct. And I think it probably had that on, and I probably have it in a different slide. Because you're right, there is a disconnect, because communication from counsel is generally privileged.
That is generally
if it's dealing with pending litigation.
Okay.
Employment contracts, again, are public records. So if you have a negotiated, you have a collective bargaining agreement, those are going to be public records. If you have an employment a contract with a contract employee, those are public documents also. Where was I here? How long does it take to respond? Well, what it says in the statute, you should promptly respond. But there is just what we call the initial 10-day letter. So I get a request, or you all get a request in the mail, and it goes over to the superintendent's office, and it says we want items A through Z under the California Public Records Act. So you have to have time to decide whether or not you have it in the first place. So what we do is usually send out the initial 10-day letter and says that we may have documents that are, or we have documents that are responsive to your request. For example, they ask for a copy of the audits for the last 5 years. Or we have documents that are responsive to your request, but we plan on producing them by this specific date. That's generally how I handle them. Because it may take you time to go back and get for the last 5 years, find where all your docs are, put them together, pack them up, send out the copy or receive the check ahead of time, because it's going to cost you so much money to produce these documents, and you send it, you provide it to the requester. So that's what I call the initial 10-day letter.
Is it unreasonable to ask for money to cover the
copying costs? And it should be in your, I believe it's in your, are you 25 cents here?
Or 10. Well,
okay.
It's only the copying costs. We don't get any
labor.
We don't get any cost for labor. All the time used to locate. It's just the direct copying cost, which means a person standing in front of the copy machine.
I guess this is what concerns me, is that our staff is so depleted now because the budget cuts that there aren't a lot of people. I mean, one person does a lot of things, and if one person is spending a lot of time standing at a copy machine or looking for things, maybe they can't do it as fast today as they could 6 years ago. So how do you decide what reasonable is, and everybody can accept that as a reasonable amount of time?
Yes, well, what you have to do is send out, well, you know you have to send out the initial 10-day letter. And with that, you can kind of you can calculate in the amount of time it's going to take you to respond, because you may say, here's your initial 10-day letter, we'll have the documents prepared by March 15th.
So all work doesn't have to stop because the public come in and to spend, so this one person spends all of their time getting this together as opposed to doing their other responsibilities.
Very, very good point. It doesn't stop because you have a request. You can produce it within a reasonable amount of time, and you can ask for the cost. It certainly doesn't cost, it doesn't cover that hour's worth, what you're paying, that employee to stand there, or the couple of hours for the employee to stand there. But you're charging 10 cents a page, I believe. And so that's
other districts that are charging a quarter.
Yes, I do.
Is that reasonable?
Actually, maybe more. Yeah, because the 10, I think 10 may be a little bit low given the amount of time that it takes. Plus, what the going rate is for the copying too, because even if you have to make a copy for someone, it's generally more than that. But you all can decide, and it's within your board policy. Should be established in your board policies.
I just want to make sure that, okay, so we have this board policy, and we have tried to be reasonable and fair, and then we're criticized because we're slow. And, it was decided it was reasonable and fair, but then we're criticized because we're not producing it as quickly as that person would like. For their purposes, then.
Well, I think you have to do what you have to do, and probably what I'm sure that Greg does, is the explanation is included in the letter. Because of the volume, and there exists, I'm going to show you exactly what it says. Let me tell you, because, here you go, here's the extension. And you can ask for up to additional 14 days, because they may be archived. And if you have to, and sometimes you have to go to those warehouses, literally pull the boxes and pull them out, and therefore you're going to say, we need additional time. There may be volumes of docs that you have to go through, and you say, we need additional time. So I usually identify the reason why. For example, the other day I said, well, there's been a change with legal counsel, we haven't received all the files, therefore we'll be producing them on this specific date. So so I gave the explanation. So the important thing is that the other side knows why there is a delay. In their mind, a delay or extension of time as to when they'll, and give them an approximate date as when they'll get it. It's not like you didn't notice them, so they have the information. But literally, you do not have to stop what the business of the district to get to one particular request, because you have more requests out there and more individuals you have to address. Yes, sir.
Yes, from the standpoint of the document that's behind the desk, the folder that's being used for the project, what have you, a reasonable request, if the folder is there, maybe not an index to the folder, maybe the folder has some parts of it someplace else, the reasonableness for a prompt request, it's not archived, it's not something what have you. I would think that the 10-day letter automatically, which is potentially unreasonable, it shouldn't be automatic 100% of the time. That's one question. The other one is that in court, I've seen people come in with their own copying machine. I said, you know, they lock the room, you copy it, and you can have it, and you don't destroy it, what have you. So that can be another option. Hey, bring your own copy machine in, you know, if you really want to do it. And that's an option with the employees not involved. But let's go back to the prompt situation. You have an ongoing situation whereby you have a file on a construction project, and there's a timeline for it being met. One with the public, and it's there behind the desk, and the staff is theoretically able to observe, maintain some type of security from the standpoint of not walking out the door overhead. Isn't that a reasonable situation?
Well, and I would say that staff, I believe staff always tries to be reasonable. The problem is, and the issue may come up, is the request comes in, but there are other requests in front of that, or there were reports that had to get out, or there's something that you have to deal with department number, you know, over in HR, or you have to get the curriculum to deal with. So it has to be reasonable in terms of not only the requester, but the responding agency. So I think what they do is, if they can get to it, they get to it. Otherwise, that's why the legislature said, you have to give at least a 10-day notice. So put it in order of priority, I think. And so if they can get to it in one day and they get into it in 2 days, I'm sure they'd like to present it that way. But if they